Hey, Brian Parker here. Got another exciting video. This one's called Debt Collection Defense A to C, Affidavit to Counterclaim. I just did a video and I wanted to do these two sequentially such that I'm always touting and talking about the Counter Affidavit. Whether they file an affidavit against you or not, it serves you well to get your side of the story out there if that's the way you want to go. I don't tell you how to practice law or practice life. I just give you the way I do things. And when doing one of these affidavits, I gave you the free PDF cheat sheet on collectionstoppersolutions.com. It's free. Go there anytime and grab it. Remember this acronym, the word code, C-O-D-E. C, cite on the affidavit what the plaintiff did wrong, the debt collector, and cite their documents. Remember what my rule is? Hello? Hello? It's use their own documents against them. O, object to what they allege in their pleading and lawsuit, and take the paragraph which is obviously wrong, stick it in your affidavit. D, dispute. You may owe the debt, but you don't owe it to these guys. So make sure in the affidavit it says, I dispute owing this debt to plaintiff. E, everything. Everything you've got, put it in that affidavit. Every violation of law, everything they did wrong, all their pleadings, all their paperwork that helps you, put it in the counter affidavit. There you go, that's code. So the counter affidavit, once that is done, that is the basis of everything for you to respond to. And it helps you also go on the offense. How do we go on an offense in a debt collection defense? We file a counterclaim. Now there's a way to do this, and follow how I tell you to do this with these notes, and hopefully it will work out. I want to tell you, we've got a snooze alert, S-C-H-N-O-O-Z-E. Look for the snooze alerts, okay? The counter affidavit is the base of everything. So your answer, the counter affidavit, once created, will fall right into your answer. The counter affidavit will fall right into your affirmative defenses. The counter affidavit will fall right into your counterclaim. So it is the pinnacle, the basis, the foundation, the genesis of how you're going to win, either win the case, get the debt settled for a better debt than they're offering, better amount than they're offering you, wipe it out, or sue them. So once you've created the affidavit, I'll tell you what, let's do this. I'm going to give you an affidavit right now, a couple of pages. This is an affidavit of a case where the gentleman was sued in the wrong district, beyond the statute of limitations, and through with documents that did not show his debt was passing from the original creditor to the company suing him. I think it's SC, Security Credit Services. So let me give you the first page of the affidavit, Shazam, and you can see right there, 1 and 2. The client is saying, the address on my state ID. By the way, when they search you and try to find you to serve you and sue you, that's where they go. They go to the voting records. They go to any state database that's cheap to create. Also, by the way, before they sue you, if you're wondering why you get collection letters, that's their attempt to improve the demographic and location of where you're located. So they store all the information that these letters create. If you call and go, hey, you got the wrong guy, or you call and say, hey, I don't, they capture everything. So be careful. That's why those letters go out and then the debt collector disappears that originally contacted you, and then another company sues you. They're data mining. So anyway, my client says, hey, my state ID is clear. I've lived there all my life. I Googled my own name and address. And after I discovered this judgment against me, I found that you'd sued me in the wrong court and an address I don't live at. And he says, underlined, I don't live in the area where the court is. So if you will look at number 8 and 9, Shazam, 8 and 9 of the affidavit, Shazam. 8, I learned that after they sent letters to the wrong address, they had pulled my Experian credit report. So they're going after him for a debt that's way beyond the statute of limitations, suing me in the wrong place, and then they went ahead after that and pulled his credit report. This is what they do. And then you'll see number 9, I did not receive anything from anyone advising me of my rights to dispute. That's paramount. If you're going to collect on someone, especially if you're going to collect on their credit, you have to provide them with the validation rights. I've yet to see that letter in this case. It's been going on a while. There's nothing that proves they ever did that. So that's in his affidavit 8 and 9. And then just focus on 23, Shazam, that shows paragraph 23. And Shazam, there's the rights they claim give them the right to chase my client, which, by the way, are missing any proof that SES has the right to chase my client. And you can see through 26, Shazam, that would be the third page up there, I've detailed what they did wrong from their own paperwork. So that's an affidavit. So once you've got that affidavit and you've used code CODE, cite in your affidavit all they did wrong. Object to their pleadings. In that case, I didn't want to put too much on here, but in that case, even their pleadings showed that they weren't appropriate. And then D, dispute. Always make sure you dispute owing the debt. Even if you owe it, that's fine, but you don't owe it to this guy. If you can safely say either they didn't meet their burden of proof, or you just don't owe it to this guy, or they have no proof, you may owe the underlying debt, you are allowed to say only the truth. So I don't owe it to this debt collector. Quick side pro tip, when you're in a pretrial or anything in front of the court, never use their name. It's not Miss Smith or Mr. Jones. It's debt collector, debt collector, debt collector. Put that image in the court's mind. E, everything. Everything that you have that can prove your case, bring it or lose it. You snooze and you lose. So that affidavit is what was the genesis, the basis, the foundation of everything I do from that here on. Even if they file a summary motion, in this case, they didn't. Even if you have to file a mediation brief, in this case, we went to mediation. Exhibit number 1 was the counter affidavit. Courts, case evaluators, whoever, don't have time. A nice preliminary statement at the beginning of your answer, mined from the affidavit. So let's put up the first page of the answer I filed in this case, Shazam. And you can see I'm referring to Exhibit 1. What's Exhibit 1? What is Exhibit 1 in everything I do and preach to you? It is the counter affidavit. And the counter affidavit is created how? What do we rely upon? What do we use? Hello? Hello? That's right. You're always right. Use their own documents against them. That goes into your counter affidavit. And that is a powerful statement of your intent, of your defense, and why you should win should it go to a counterclaim. Go to page 2 of my answer, Cindy. Shazam. I make no bones about it. Look what I wrote. There is no perfected chain or title or assignment from the original creditor to plaintiff. Am I required to write that? No. Is there a rule against me doing that? No. Why do you do that? Nobody else does that, Parker. Because I can. I want my denials big and bold, and so do you. Take control, set the tone. Don't be a victim. Do things that put you out in front as you're coming for battle, man. So you can see in that same page, also attached to complaint is an affidavit of debt and verified bill of particulars saying the debt was charged off and sold to Security Credit Service. Well, that is in my affidavit. So you will see, go to page 3, Cindy. Cindy. So go to page 3. That's their assignment again. Remember, I just talked about in the affidavit saying, yep, we own it because we say we do. And then I go further. The affidavit identifies Mr. Debtor, my client is Dorothy Debtor, as a defendant and SES as plaintiff long before the lawsuit was filed, and various other reasons, as you can see. So your counter affidavit is your answer, is your counterclaim, is part of your response and reason why you should win in a summary disposition hearing. It's part of your trial brief if you go that far. It's part of your mediation summary. It's part of everything you do. You will have done 90% of the work you need to do to disprove their claim. By the way, you don't have to do a thing. The burden of proof is on the other side. But don't get into that false safety or security. Come out swinging. Show why they haven't met their burden of proof. Using, that's right, their own documents against them, which is inside the affidavit, which now is inside the answer. And remember also, we put defendant preliminary statement as to no stated claim. So I'm going to attach to the membership site this actual affidavit in Word, so you may use it if you wish. The answer we just mentioned and how I write it down. There's plenty of videos where I do that. And we're on our way. So we have another snooze date alert. You snooze, you lose. When you file an answer that I just showed you with Exhibit 1, which is your counter affidavit, the very basis, genesis, foundation, platform of everything you're going to do to defend yourself and tell the court, hooray, I get to show you why they're bad and I'm good. You will file the answer with the affidavit and affirmative defenses, which will be cited in the affirmative defenses, Exhibit 1, and your counter affidavit again. But this is important. When you are dealing with a debt collector, when you first reach out to them with your answer, and please do this, don't do the counterclaim yet. You may not need to, but send them the answer with your proof and a nice statement saying, here's why you're going to lose this case. I'll put on this site what I said, why we were going to lose the case and why the other side was going to, why we were going to win it and the other side was going to lose it. And then I say, if you don't respond to this in 7 days, I will file a counterclaim. So don't make any threats you're not going to follow through with. What are you doing there? And why is it a snooze alert? Because you have a certain amount of time, obviously, to file an answer. If the state says you got 20 days to file an answer, don't snooze, get that served, the answer. You also may want to engage the debt collector or law firm before you answer to save yourself time and energy, but then have a hard and fast rule. On the 15th day, I'm filing my answer. So when you file your answer, file your email accompaniment saying to the other side, I'm filing a counterclaim and here's why. Look at my answer, look at the counter affidavit. And then hard and fast rule. If you give them, you say, by May 7th, I just wrote the thing today, May 7th, if you don't settle this, I will then file a counterclaim and then we're going to incur more costs. So that saves you time and energy. You've got a good case because you did your counter affidavit. You're not just supplying an answer going, deny, deny, deny. They're never going to listen to you. You show them how they screwed up with their own documents. No attorney wants to deal with that nonsense with, frankly, a pro per person. And a judge will give you space because you're not represented by an attorney. Don't worry about that. So go to a couple of my videos. There's one that says how to talk to a debt collector. There's another one, how to talk to a debt collector attorney. There's another one, I did a 4-part series, 4.5-part series called the ABCs of Debt Collection Defense. I'm pitching here, but if you're on my membership site, you're going to see how great these are. Part 1 specifically says to you, set the tone. You come in, you have the counter affidavit, and you say, settle this debt, here's what I want. I always say I want out. So I want the debt eliminated, or I'll file a counterclaim in 7 days. So the snooze alert is, go to your state rules and find out how many days you have where you can legitimately file a counterclaim without asking the court for permission. So in some states, you got to file it when you serve the answer. In Michigan, for example, you've got 14 days generally. Even if you filed the answer, you can wait 14 days. And so that's what I do. I go, hey, if you want to settle this now, I'll save you the cost on a $5,000 case from a debt buy, which is worth $50. You won't have to incur counter affidavit and counterclaim, supporting a counterclaim. Let's just get this done. And then if they blow you off, do it. Because A, you don't want to miss the statutory amount of time you have to do it. You can always go do a motion to ask the court to let you do a counterclaim. Don't want to get into that. You want to do it where you got a freebie. And then secondly, you got to set the tone. That's what I say in part 1 of debt collection, my ABCs of debt collection defense video. And I'm saying it before I told you that, and I'm saying it now. Set the tone. That counter affidavit is a tone setter. So be hard and fast, set the tone, keep your dates, and look out for the snooze alerts. So on the screen now is what I did with my counter claim. So the counter claim, let's put it, and this again, this is on my membership website. Here's the first page. It will look familiar to you. It has the similar underpinnings of my answer, the first page. What do they got? Got a preliminary statement, right? Now, keep in mind, you're suing them. So now you have the burden of proof. If you've done the right thing with your counter affidavit, you already have the burden of proof to sue them, and you don't want to sue them until you have to. If you have to, again, Shazam that first page, there's the preliminary statement. You've already done the work in the counter affidavit. You cut and paste from the answer with the preliminary statement. SCS has no ownership, assignment, chain of title to collect on this, blah, 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 blah. I've thrown in a couple of things there. And that's your counter affidavit, that's your answer, that's your affirmative defenses, all written for you with the counter affidavit, and now it's your counterclaim. So look at paragraphs 38 through 42. Let's put those up on the screen, Cindy. And you can see, citing Exhibit 1, the affidavit, all the allegations I have against them that they now have to answer for and will be paying you money if they can't beat you. So if you win the underlying case, which we prevailed, I got to be careful, we prevailed where both sides were happy. If you win that case, you probably win your counter affidavit. But in this case, the counter affidavit made both sides take a look at things. So we sued in federal court. I went after the law firm. And so that was fun in that, Cindy, let's put up what we sued the law firm with in the federal court. By the way, the federal court case is, it was mentioned in filing a federal court and avoiding Article 3 standing issues, or how to file in federal court. Those two videos are based upon these actions and this action that I'm going to tell you about. So in the federal case, I sued under 1692I. What is that? Can't sue someone in the wrong venue. Remember, the affidavit said, paragraph 1 and 2, I don't live in the place they sued me. 1692F, unfair practices. You may not use unfair or unconscionable means to collect on a debt. They went after the guy's credit report and then got a default against him in the wrong district without serving him. 1692E is like a panacea. There's a whole bunch of ways that the debt collector violates the law. So in this case, we went after them 1692E2, false representation of either the character amount or legal status. They sued him in the wrong place for a debt he no longer owed because of the statute of limitations passing. 1692E5, the threat to take any action that cannot legally be taken. You can't sue someone once the statute of limitations is passed. As I'm saying these things, remember I just talked about that's all in your counter affidavit. So all the work is being done for your federal case. So you're golden there. 10, the use of any false representation or deceptive means to collect or attempt to collect a debt. And then you remember I talked about how they hadn't sent him his validation rights in the counter affidavit, 1692GA. Within 5 days after the initial communication with the consumer in connection with the collection of the debt, you've got to send him or her the amount of the debt, the creditor, a statement of all his rights, and he has a right to dispute in 30 days. None of that stuff was done, as we said in the counter affidavit. So he's got a violation of law. Had they done that, maybe things would have been different if they just followed the law. Now, remember I mentioned how they contacted his credit in the counter affidavit? I sued them under the impermissible purpose doctrine, 1681B, which says you got 6 ways you can contact someone's credit report. Any other way is false. You cannot contact someone's credit report if you don't have the right to the debt or the right to sue them in this case, or both of those, and you don't have proof you own the debt, which they didn't. So I went after them, and I'm still going after them for that. So look at my membership website for the fantastic affidavit. Here's all the videos I have, I think. Cindy, put all the videos I've got on my membership website, and just do this as counter affidavit specialties. There's various videos on counter affidavit and how to write them, including put up for the people, for my friends, the free PDF check sheet video where I give you a video explaining how to do this. I've given you that word code today, right? And what does code mean? Let's do it one more time. Cite on the affidavit where the plaintiff did wrong and cite the documents. O, object to what they allege in their pleadings. If you can take one of their, I just did a case today, I look at my computer. I just did a case today where they said my client became indebted to the plaintiff upon use of the credit card. The plaintiff is a debt buyer 5 years down the road, I think, from when the debt was initiated. So that's an impossibility. So I put the paragraph 2 in the affidavit, their lawsuit paragraph 2 in the counter affidavit, in my pleadings answers, in my affirmative defenses. And I said, you settle this or I'm going to do a counterclaim. And that will already been done for me. That lands right in the counterclaim. D, dispute. I do not owe it to this plaintiff. Say that legitimately and truthfully. If they haven't proven to you, met their burden of proof, which is the very genesis and basis of your affidavit, you can say that. Because sometimes a judge will say, but you owe it, right? And it's like when a cop pulls you over and they go, okay, do you know how fast you're going? Don't answer that. Say, I didn't look. Because if you say, yeah, I owe it, he'll cut you off and so dismissed, they win. So I don't owe it to these guys, right? E, everything. Put everything in the kitchen sink that legitimately belongs in there, because if you don't, you snooze, you lose. So if you don't put it in there, you lose, or it gets real tough to get it in there. I have a video on amending pleadings. Cindy passed it along. If you get to where you can amend, which allows you to do your counterclaim. But the long and short of it is that the counter affidavit is everything. Whether it's required or not, your good defense is always required, and it just could settle your case for a lot less than you thought you were on the hook for. So don't give up. Once you've done that counter affidavit, it's 90% of the work, and you just use their documents, which is 100% of the proof. Okay, I hope you see it like I see it. I showed you all those videos because there's so much on my Collection Stopper Solutions website. It's fantastic. Just check it out. There's two free things. There's actually a free PDF. Cindy gave that video on how to create an answer. I've given you a free PDF, how to create a debt collection answer. All right, long video, but it's very helpful and wealthy with information. Love, like, and describe how you want to subscribe. Okay, thank you very much. Rock and roll.